Hello and good afternoon, everyone. This is the second plenary session that will be on AI and liability in the EU. To start with, we have two speakers. The first is Professor Montagnani, who is Professor of Commercial Law at Bocconi University in Milan, where she teaches and researches in the field of law and technology. And we also have Ms. Najjar, who is a research and teaching assistant also at Bocconi University in Milan, and acts as a coordinator of the LLM. So I'd like to invite both of them, if I may, to start their 20-minute presentations. And are you ready?
Yes, thank you. Yes, we are ready. Good morning. And
yes, good morning your time. Yes.
Oh, yes. Good afternoon.
Yeah.
So my name is Marie-Claire Najjar. Thank you for the presentation. And I will be presenting as, unfortunately, today, Professor Montagnani could not join us.
Sure.
So I co-authored this paper on the EU regulatory approaches to AI liability with Lila Montagnani. And I'm very happy to discuss our thoughts with you, and I'm eager to hear your feedback. So the way in which I'm going to divide my time today and organize it is by starting with the AI features and how they challenge the traditional notions and the traditional regimes of liability. And because in order to fill these gaps, the EU has started adopting a policy towards an environment of trust for AI. That is what I'm going to tackle next. And I'm going to end with the current proposals for the EU proposed AI liability framework, which is both which we define as both composed of the ex ante and ex post regulations. And then I will conclude with some thoughts about those. And so we often hear that we cannot teach old dogs new tricks. But what I'm interested in today is understanding whether we can take old notions, so those of liability, and teach them new features, so those of AI. If we divide those features of AI in two groups, so to say, we can see more clearly how they impact and how they challenge the notions of liability. So on one side, if we look at so on your left-hand side of the slide, you can see the features of openness, data-drivenness, and vulnerability. And why do we say that these challenge the traditional notion of damage? So the combination of those features are going to enable the harm of further categories of protected interests. So these can range from privacy to confidential information, security such as cybersecurity. And this is where the challenge of the notion of damage arises from. For example, AI systems constantly interact with outside information, which means that AI can be vulnerable, for example, to cybersecurity breaches. On the other side, we have a group made up of complexity, opacity, autonomy, and unpredictability. And those can challenge two core notions of traditional liability regimes, which are the causal link and the duty of care. So in liability claims, we know that claimants have to prove that the damage originated by some particular conduct, by some particular risk that is attributable to the defendant. But the problem with, for example, interconnected devices or machine learning systems is that providing evidence of causation becomes more and more difficult because we have different actors or different causes, sometimes even successive causes, that could have contributed to the damage. And relating to the duty of care instead, which is a central notion of full-based liability regimes, it's also difficult to apply to AI systems. And here we argue that this is the case for different reasons. So first, because there are no established models of how they should function when they learn without direct human control. So how such systems, such AI systems that can be autonomous should function, for example. And also because the standards of care that are designed for human conduct cannot always at least be applied to AI systems. And because such concept of duty of care would require to identify a person that would be obliged to meet such duty of care. And this is, again, not always possible in the case of AI systems. So these three notions are rooted, these three notions and other ones, they are rooted in member state liability regimes. On that level, so on the national level, harmful damages that arise during the use of AI, they are likely compensated by national tort law, national contract law, or applicable liability provisions, for example, for automated vehicles. And the core and common concept, let's say, to these regimes are fault-based liability, but there are also differences. So in some premises of this fault-based liability, for example, the burden of proof, but also in some specific provisions regarding non-fault liability or liability for others. And this is where we get to the EU liability regime, which is only partially harmonized and the existing tort law is limited to liability for infringing, for example, data protection law or competition law, and the current product liability directive. Now, with the proposed framework, we could have an expansion of that harmonization, let's say, of the EU liability regime. And just to get back to the current PLD, we know that it's implemented into member state liability regimes, which in theory should result in harmonized strict liability. But in practice, there is still some inconsistencies and some fragmentation on the EU level. And also, of course, its scope is limited to defective products only. And because of this fragmentation, there has been a discussion around the need for further policies. So due to this gap in the AI liability legislation, the EU has started adopting a policy towards an environment of trust for AI. As you can see, there have been already different steps towards that and throughout the years. And I'm not going to go through the details of each one because of time constraints, but what I'm interested in pointing out is the objective that this policy has. And so all these steps point out to the goal of having efficient rules for AI, including for liability. Why is that? That is because it would lead to an environment of trustworthiness for AI and placing the EU on the international stage, for example, in innovation. This would require, of course, the need to balance between different interests, so between the protection of consumers, but also innovation and promotion of investment. So in order to achieve this balance, the EU policy has led to the proposal of a framework for AI liability, one that we propose to define as a bipartite model. So why bipartite? It's because on one side, we argue that there is the ex-ante regulation, so the preventive measures. And those would encompass both the proposed AI Act and the proposal for a revision of the machinery regulation. We define those as aiming to govern AI through obligations, through safeguards for non-compliance, to reduce risks of damages, and to enhance market surveillance, safety, trust, and so innovation and competitiveness. However, when such compliance is not enough to guarantee that harm does not materialize, that's where the need for ex post regulation comes into place, so compensatory measures. Those encompass the AI liability directive for damage caused by fault, and the revised product liability directive for damage caused by defect. Those are complementary, and we will see later how they function. But they aim to ensure AI liability, and they insist on the importance for compliance with the ex-ante regulation. So basically, they aim to guarantee the same standards of protection when AI comes into play as it is when AI is not in the picture. So both the ex-ante and the ex-post regulation contribute to the same liability framework, because that lack of compliance with obligations from the former would lead to liability as per the latter. And if we focus on the AI Act, so one of the components of the ex-ante regulation, we can see that in order to minimize risk, it differentiates between different types of systems, of course, with respect to the risk that they pose. And it can go from, and it imposes obligations that can go up to prohibitions, for example. And looking more into the high-risk AI systems, we can see that the AI Act sets out some obligations that can range from transparency to safety and robustness. And these obligations are allocated between different operators. And this is the same logic that is applied in the revised machinery regulation. So again, we have obligations in terms of transparency, in terms of accountability, for example. Those obligations are again distributed between different stakeholders. The reason why the machinery regulation is relevant to us, and we're discussing it today, is because it is complementary to the AI Act in regulating AI systems when they are implemented into machinery products. And when the obligations that are set out by the AI Act and the machinery regulations are not respected, are not complied with, we have penalties set out by the AI Act and the machinery regulation. The question here is to understand whether those penalties constitute a way to hold parties liable indirectly for AI-generated harm. So the idea, answering this question, would also require answering the question of, if harm materializes because of lack of compliance, who should compensate for that? The problem with the AI Act and the machinery regulation and the gap that remains is that there is no status recognition, no procedural rights, and no complaint mechanisms in those. And this is a gap that is aimed to be filled by the proposed liability directive, both the revision of the product liability directive and the AI liability directive. So if we look at the revised product liability directive, of course, to fill these gaps, there have to be changes with respect to the original PLD of 1985. So those changes can regard the subjective scope. For example, now it encompasses also a person that has modified the product even after it has been placed on the market, which is relevant for emerging digital technologies and AI. And the objective scope, as it encompasses, for example, now into the notion of product, it encompasses software and thus AI systems and when they are embedded into products. And also the notion of damages now encompasses another concept, which is the loss and corruption of data. And that is new with respect to the original PLD. It also recognizes that software updates and upgrades can have an impact on liability. So they can make a product defective, and thus they cannot be invoked to escape liability. A third important point regarding software updates and upgrades is the fact that when they are necessary to maintain safety, for example, to face cybersecurity vulnerabilities, failing to provide them could also entail liability. And here for both the PLD and the AILD, we have some core concepts for AI-caused harm. And those revolve around evidence disclosure, which aim to overcome the opacity of AI systems, and legal presumptions that are rebuttable. In the case of the PLD, those regard defect and causality between this defect and the damage. And the same applies to the AILD, of course, with its specificities. So there is also the evidence disclosure, but the rebuttable presumptions regard non-compliance with duty of care, and the causality, again, between this fault and the output or the failure to produce this output, which gives rise to the damage. And for example, with the AILD, the rebuttable presumption of non-compliance with duty of care can be rebutted by providing evidence, for example, the one that is set out by the evidence disclosure order. And that can be done through correct documentation, correct logging, which points to the importance, again, of complying with obligations that are set out in the ex-ante regulation. So the AI Act obligations regarding transparency, regarding accountability. By complying with those, one could rebut the presumption of non-compliance with the duty of care, for example. And this is just one example among many. And so, sorry. This framework has already pointed out at, it has already been pointed out that some criticism regarding this framework. And the way in which we have proceeded is that we clustered this criticism into three main ideas. So criticism on the uncertainty in the coordination between the various provisions, criticism on the approach, so the three different types of approach that we're going to tackle now, and the overall effect of these on the effectiveness of the framework at various levels. So regarding the first point, so the uncertainty in coordination between the various provisions, we first have, for example, the potential overlap between the AILD and the revised PLD. In theory, there is no overlay between the AILD and the PLD, but that refers to the old version. However, this differs from the revised PLD, so there should be some discussion here. What happens if both apply, for example? The allocation of the burden of proof remains somewhat unclear. So should the presumption of defect from the PLD apply, or do we still need to prove a fault under the AILD? There has also been criticism regarding the limitation of the liability directive scope. And I think you'll probably hear more about that from our colleague, Professor Hacker, on some of these issues, as some of these issues were discussed in his paper. And regarding this delimitation, for example, we take the example of complex algorithms that are not AI, but still do pose some risks of harm. So they would fall under the scope of the revised PLD, but not under that of the AILD. And this is an issue that should be discussed and addressed as well. Another point regarding the uncertainty in the coordination is, of course, as often the choice of directives as legal instruments. So because of the divergence in national law, we have the possible divergence in national law once it's implemented. We could have some legal uncertainty, or, for example, notions that are still left to the court interpretation, so unclarity on some notions, both in the AILD and the revised PLD. And this also applies for some requirements in order to apply the presumptions, the legal presumptions. This means when the court has to interpret such notions, it means that it should understand the functioning, the characteristics of AI, and the safety standards of different sectors. Instead, when we talk about the criticism of the approach, we refer to three characteristics of this overall approach. So the fact that the AI Act's risk-based approach is applied to the AILD. So the material scope of the AILD, of course, is aligned to the AI Act definition, and that is deemed crucial. But also some of its core principles are aligned to the risk-based approach. And even though that fosters coherence, there are also risks. For example, not including into the framework the risks which are individually pronounced, but overall, so their distribution in between society members makes it that the aggregate risk is too low in order to classify as high risk level. Other criticism relates to the adoption of the horizontal liability regime, which applies to various sectors. It has been argued that there is no one-size-fits-all solution, since there are differences between different AI applications. And that leads scholars to encourage, for example, range of options or ad hoc sector-specific regimes, which are tailored to this peculiarities and specificities of different AI applications. So the idea here basically is that since liability in different sectors needs to be regulated by different frameworks when AI is out of the picture. So for example, in healthcare and between healthcare and vehicles and transport. So why is it the case that when AI is used in both sectors, it would be the same framework that applies? And finally, we have the approach toward the alleviated claimant's burden of proof, which is also criticized because it is believed to still put a heavy burden of proof on claimants, for example, before presumptions and evidence disclosure can be applied. In the case of the AILD's causality presumption, for example, claimants still have to prove non-compliance with the requirements of the AI Act. So it's believed that there is still a heavy burden of proof, and this alleviation was it was made as a compromise, but between different types of regulating liability, but it's believed to still have a heavy burden of proof on claimants. And finally, regarding the overall effect of these issues and this criticism on the effectiveness of the framework, we analyze different levels. So on the level of the organizations, of the consumers, and the overall harmonization, which also includes the directives. At the level of organizations, even though this framework is not already in place, if organizations are investing in AI, it's recommended and important that they start accounting for this new framework, because this could allow them to avoid some risks once the framework is in place, when they deploy the systems, for example, that they could have started working on before the implementation. And for example, for high-risk AI systems, we could have appropriate security monitoring or interruption of the AI systems. And of course, all of this accounting for the new framework can be done through training. And otherwise, if there is not such appropriate security monitoring and interruption, there would be the need to rebut the AILD causality presumption. So again, that's where we see the interaction between the obligations of the ex-ante regulation on one side and the liability of the ex-post regulation on the other side. Regarding consumers, so even though directives do aim to facilitate those claims for compensations, like we were saying previously, it remains complicated to prove some concepts. And even though the PLD revision aims to overcome these challenges, it is limited to some harms. So for example, with credit scoring, we cannot rely on the PLD, as this can only be done through fault-based by proving fault under the AILD. And this is why overall the harmonization could be argued to be limited, and to confirm the fragmentation among member state liability regime. And there is still some margin for increasing this harmonization, and of course evaluating it in light of the national implementation of directives with respect to the direct application of the ex-ante provisions. Thank you very much.
Thank you very much, Marie-Claire. That's a very good presentation. So thank you very much for that.
Thank you.
We now we'll have questions at the end of all the speakers. So please do feel free to add your questions to me in the chat box, and I can present them later. Let's move on now to our second speaker, Professor Ponchibo. And Professor Ponchibo is a professor of comparative private law at the University of Turin in Italy, and is also a faculty member at the Georgetown Law Center for Transnational Legal Studies in London. And she will present on private governance of artificial intelligence, EU perspectives. So, Professor Ponchibo, over to you.
Thank you very much indeed, Ernst, for this very kind introduction. And I'd like to really thank the organizers for inviting me to join this conference. I have to say that the first presentation was really, really interesting to me, and my topic perfectly fits and follows what Marie-Claire Najara has just said. So if I may, let me share some slides from my screen. Can you see the slides?
Yes, we can. Thank you.
Okay, thank you to you. So basically, among the many different, problems and interesting research questions of the EU proposal about the Artificial Intelligence Act that has been, and as you know from Marie-Claire presentation, in the EU we are very active today. So we have also the AI product liability directive. We have a number of initiatives by EU institutions. So within this discussion, my attention has been, raised on the issue of the role of standards, basically. And there is a reason why this specific issue has raised my interest, my attention, being a private law scholar, basically. And the reason is very simple. In this proposal for a regulation on AI, and then in the so-called AI Act, and in central to the AI Act, the European Commission has made clear that they think that a prominent role has to be played by standards. And as it has been said, this regulation seeks to introduce a very complex patchwork of safety and trustworthiness requirements, especially for high-risk AI systems. So there is this distinction depending on the risk that the AI system may pose to society. So there are these requirements, and they address a number of areas, for example, risk management, data quality, transparency, human oversight, accuracy, and cybersecurity, and so far. Just to give you an idea that we are talking of a number of areas that are touched by this initiative. But with a view also to contain the compliance cost for the providers of AI risk systems, so innovators. Within this regulation, we have the articles 40 and 41, and they establish a presumption, basically, of conformity with these requirements for systems that comply with harmonized standards, and in case of absence of harmonized standards in the EU, about common specifications. So this, to me, seems that this presumption, is first an incentive to follow standards and create, EU harmonized standards, EU approach to these issues of conformity. And I think it's fair to say that these standards have a crucial role. And they provide to all the operators details about design, development, and deployment of AI technologies. They address the whole process from invention to consumer. And for this reason, many questions have to be answered about the role they play, because the entire system is probably grounding on EU standardization. Now, this is the EU way, basically, and we have this EU activism, we have this central role for standardization, and we have this couple of articles that are basically putting on the shoulders of our European standardization bodies the task of fixing the rules of the game. Obviously, these are, not the only relevant standards, not only in the EU, because we are talking of different levels. Now we have the international level, we have the regional or EU level, but we have a number of also of national standards, then professional codes, guidelines, and also some uncodified best practice. In my research, my focus is on European standards, harmonized standards, mainly, but I mean, we have to be aware that we are talking of a variety of different things and having different role, having different force according to the law. And this centrality of standards has already raised some criticism, some questions by scholars. So Locke and others and other well-known authors, they have a question recently. I mean, future standardization work, they say, on AI by European standardization organizations will be unlikely to produce detailed, specific, and coherent normative thresholds and requirements for the development and use of AI. So much to do about nothing at the end. So it's very important that we assess. I'd like to also to comment with you about what kind of standards we are talking about when we discuss of artificial intelligence systems, because I've been quite surprised to see that basically these standards are also posing criteria that are technical, but they can tell you what fairness is in practice. Because in order to discuss of fairness and trustworthiness of the AI, at the end of the day, you need to assess the design of these systems, and the design, this sort of way of developing this kind of systems has to be fair. And what is fair, what is fair if in the design, the producer, the innovator, the developer has followed the standards. So they are about ethics as well. They put ethics into practice, and you assess how fair, how ethical these systems are at the end by looking to the fulfillment of standardization criteria. So, I mean, they have some ethical goal that is not precisely what you expect usually for technical rules, in the sense that traditionally, this is also quite a traditional topic in private law, but anyway, this is talking of fairness and ethics. It's not only assessing respect of road of safety. And let me give you an example. There are many initiatives, and also at the global level, and they are so ambitious. They have so wide-reaching goals. They think to society, not only to industries here. They say for example, there is the Institute of Electric and Electronic Engineers that has these global initiatives on ethics of autonomous and intelligent systems. They say we would like to ensure that these systems are educated, trained, and give priority to ethical considerations, so that these technologies are advanced for the benefit of humanity. So I think here standardization experts have quite an important and far-reaching goal with respect to emerging technologies such as AI. This is also, I mean, something that is going to fit in a traditional framework. The one that is well known is EU approach to standardization, that is mainly based on a EU regulation. It is quite dated. It dates back to 2012, and it focuses on the role of a set of European standardization organization that are delegated by EU institutions this task in a number of sectors. This is the European Committee for Standardization, the European Committee for Electrotechnical Standardization, and the European Telecommunication and Standards Institute. So these are the pillars according to the EU approach. And there is this sort of delegation of power. So they receive from EU institutions some public function, we could say. It's not only private, because it has a number of goals, and they work under the delegation and the shadow of the EU that is fixing their main rules and regulations, but then says, okay, to implement practically, you have to go to this organization. And so there are already a number of international and European standards that are touching AI concepts and terminology. They describe the framework for using machine learning technology and so far. And the European Court of Justice already in the year 2016 had the case and had a judgment about the role of standards and in James Elliott construction. And it was a case not dealing with technology, emerging technology, but it was say basically, look, standards are fully part of EU law because they play a very important role they are not per se EU law, but they produce legal effects because they are important for ruling the internal market, and they are basically necessary implementing measure providing clarification about EU essential requirements. So basically, we are trying to adapt quite a traditional tool to a completely new and different reality. And for the EU, these bodies, these standardization bodies are not entirely private, but they work under a sort of delegation and a sort of shadow and recognition. So we expect to have EU harmonized standards, and we also expect, that when standards are not passed, there will be also quite an important role by institutions and standardization bodies to fill all the gaps. And to give you an idea, references to these harmonized standards are published in the official journal of the EU, so they are openly available, and there is quite a strong role, a strong impact by these standards. One example that is important is in the EU is for sure the Joint Technical Committee 21 that has been established in between two of these standardization bodies I have just mentioned, and is a focus group on AI, on artificial intelligence, already into place since 2019. And then the Joint Technical Committee 21 about artificial intelligence is what they are doing. They are drafting standards on conformity assessment and natural language processing technologies, for example. And they would like to give guidance to other technical committees in other sectors, not specialized in artificial intelligence, when now artificial intelligence is entering a number of fields, from smart manufacturing, ICT, cybersecurity, transport system, road vehicles. So basically, we are talking of our economy here. And okay, and now this is what we have before us, in front of us. Let me pose some research questions. Obviously, is largely a technical discourse. Why you, because of this role of these bodies, have fostered the participation of stakeholders. So some of these bodies, all these bodies have now more space for non-expert stakeholders or the public at large. But basically, this is a technical discourse, and this area has been amazingly discussed by Arne Schaepel many years ago now in the Constitution of Private Governance book. It was about basic issues of legitimacy, how they are legitimate in the sense of thinking to democracy and accommodating the voices of society, how much these bodies are really capable today in facing this big and new challenge because of the diversity of AI systems from previous technologies, how they will address democratic legitimacies. They are already doing by opening, but not all the three organization bodies have the same openness and willingness to engage stakeholders. So basically, we need to discuss of being sure about democratic legitimacy here. Another question, obviously, accountability of these bodies and judicial control over these standards. In the past, we have struggled, I have to be honest, as private law scholars, to clearly identify the boundaries of judicial control and accountability for standards. We had limited case law. I think colleagues can totally agree with me. We had many important scholarship contributions, but this is a question that AI system will make more urgent, more complex because of their specific characteristics of autonomy and unpredictability. So basically, we have to question how much accountable and how much control there is on all this. And finally, being a private law scholar, I have to think to issues of liability. I agree with a colleague who has recently published on a journal I'm working, that is the Journal of Law, Market and Innovation, about this, the issue of liability. And I think in Europe, we could say, in the EU, we could say that these standards and professional rules are substantially normative. They are private, but because of this delegation by the EU, they are basically normative in the sense that they enter, and they will probably enter the courtrooms in the future, because they are usually incorporated into contracts, and they basically inform general clauses, no? And they clarify what we mean for reasonableness or duty of care and conformity. So given that it is in contract, basically at the end, they will amount to a standard of care. And if the standards are fixing the standard of care, the question is, what kind of standard of care can we develop? And there are already interesting ideas that are flowing around, for example, in an article about the possibility of thinking to a reasonably prudent algorithm. And this is based on an idea of Barfield that I think it may deserve some attention, or at least we can discuss about this. And so this idea is to use performance measures that to evaluate algorithms in court. That is to say, these are usually measures that developers of AI systems are using to test a trained model. And in using this kind of performance measures, depending on the kind of system, so it's very fair because it takes into consideration the huge diversity of AI systems. They have some sort of measure, they can measure the score of the average correct prediction about accuracy or precision and so far. So there are some possibilities of developing some shared rules and understanding about how the standard of care has to be assessed. But basically, we can be sure that European standards for AI will be the yardstick against which all professionals we will develop their performance and their conduct. So it's also quite interesting to develop with you some preliminary conclusions because of time. What is interesting to see the different genealogies of soft law. Soft law is a never-ending concept, that has been adapting over time. Now and there obviously is a question how much soft law is contributing to governing AI in between EU and other continents and other jurisdictions. There are also quite interesting comments about the fact that soft law for AI in AI systems, for example, is a process of law. So basically is a process according to which we try to code machine ethics into AI systems. So soft law now is again changing its form, its nature, its role by becoming central for emerging technologies. So a new wave and a different shape for soft law that remains a never-ending idea. So conclusions. These are not private standards. This is quasi-governmental policy specification that European standardization organization body are going to put into place for us. Do we agree that we have this state function into private hands under the shadow of the institutions? There are basically no alternatives because it's a matter of knowledge and expertise that only industry and innovators of AI system can have. To a certain extent, there is a very practical reason, but indeed there are also quite famous entrepreneurs that were saying, look, when you have to regulate AI risk and public risk, you require public oversight. But how much public oversight we will have on these standards for AI systems? And then, there is a need to focus on this area. There are already important contributions, but much remains to do. And this is the area I would like to go through and to investigate more and more, because I'm pretty sure we will be talking about in the near future again and again. And I hope to receive your suggestions and your preliminary feedback on this and the challenges that we face in standardizing AI systems. So thank you very much indeed for your attention, and I leave the floor to our chair.
Thank you so much, Professor Ponchivo. Another interesting and thoughtful presentation. So now we move on to our next speaker. And our next speaker is Professor Hacker, who's from the University, European University, and he will present on the European AI liability directives, critique of half-hearted approach and lessons for the future, which sounds very interesting. Professor Hacker holds the chair for law and ethics of the Digital Society at the European New School of Digital Studies and the European University in Frankfurt. So thank you so much, Professor Hacker, for presenting. I'd like to invite you now to take the floor and present.
Hi, yeah, many thanks for the kind introduction and for inviting me to this splendid workshop. Am I unmuted now? I hope that you can hear me now. I was muted before, so now it seems to be working. Yes. Many thanks for the kind introduction and for inviting me to this splendid conference. I'm going to be talking just a little bit about AI liability directives, but we've heard quite a bit of about this in the talk by Mary Claire and also in the talk by Christina. So I will, in fact, then try to skip over some of this content and focus a little bit more on liability issues concerning generative AI more specifically, and also comment a little bit on the vote that the European Parliament famously made yesterday on the new version of the AI Act, try to link that up with what might be intriguing with respect to AI liability. So let's get started because we have a lot ahead of us and only 20 minutes. So the current framework for AI liability, that would be my first step. And the second step, I'll try to link this up with the new AI liability proposals. As I said, I'll run through this rather quickly to then come to the third part, liability for generative AI. Okay, this is just an overview, and it's based on two papers that I've written recently. You can all find them on archive. I've just dropped the link to the chat. Perhaps the organizers can share that with the general public, or if it's not already there, you can all find these papers on my archive site. In fact, I'm right now working on an update of the second paper that has just been accepted to the ACM FACT conference, regulating ChatGPT. And I will release this today, in fact, right after the talk. I think I need about 10 minutes more to finish this. That will then include all the things that I've said and that I will say on the European Parliament rules, and also some more suggestions for the way forward. Okay, so let's start with just a quick look at the current EU framework for AI liability that has already been mentioned. And so I'll try to follow a lead example, that is a crash by a car, which is obviously one of the main incidents of liability law in practice, that now, more often than not, is also done by, or the crash is actually led by autonomous vehicles. We know that there's have been a couple of fatalities already while using Tesla's models in autopilot mode. And hence the question, of course, arises, who's liable and how does this fit together within the EU regime of product liability? So EU product regulation very broadly, and I'm just going to really present you a very brief overview here, has two components. And the first one is product safety. The second one then is product liability. What's the difference? Product safety has specific rules that are administrative in nature, and these specific regulations spell out what different products need to look like, what kind of requirements they need to fulfill in order to be marketed in the EU as such. And so there are rules, for example, for toys or for cars or for many other products. On the other hand, this product safety regime does not tell us yet who will be liable if something goes wrong, if there is an accident. And that's where we have the product liability framework for. But to make things even more complicated, there are two main pillars of that product liability regime. As you've already heard in the other talks, there is a regime at the member state level, so German, French, and Italian, and so on, regime for tort law. And this is a venerable system, of course, that dates back to the Roman times, and that member states are very hesitant to give up. And hence they have kept their own tort law systems, which in the end also contain rules for suing developers of AI systems, as we will see, or for suing, first of all, manufacturers and producers. And then there is, since 1985, a European regime which harmonizes certain rules, but that is independent, really, of the member state regime. And that product liability directive is the one that's being overhauled right now, and the member state regime is being overhauled to a certain extent as well, as we shall see. Because, as has already been discussed at length, we have now specific regulations that come in here. The AI Act is basically the pillar that will look at product safety from an AI perspective. And as I've just mentioned, yesterday we had a big vote in the European Parliament. In fact, I was quite involved with the drafting of that new proposal. And I'm quite happy to say that quite a number of the proposals that we made in this paper, Regulating ChatGPT, which we put forward in January, quite a number of these proposals have made it into the European Parliament vote and version, although not all of them, so there's still room for critique. But the funny thing about the AI Act is that it differentiates, as you all know, between high-risk and non-high-risk systems, basically. There's also a couple of other categories, but that's a really important one. And guess what? If we look at toys, toys are high-risk under the AI Act. And funnily enough, it's actually not pretty funny. It's actually, I think, a big constructional, architectural mistake. Cars, and hence autonomous vehicles, are not considered high-risk under the AI Act. At least that's what you can say. Generally, they are actually considered high risk, but the high risk rules do not apply. So that is a bit of a puzzle. I can say more about this in the discussion if you want to, but let's just remember that autonomous vehicles are not considered high risk under the AI Act. What's happening in product liability? Well, there we have these two proposals that were already mentioned a couple of times. So the AI liability directive that will work out rules in the member states. And that AI liability directive for the moment has been bracketed. It has really been put on hold in the Parliament because it's unclear whether that will ever materialize. But there are certain connections, direct connections between the AI Act and the AI liability directive, whereby a violation of the AI Act would, in certain cases, lead to a presumption of causality, for example, under the AI liability directive in member state tort law. And because it kind of develops member state tort law, that's why certain member states are hesitant to actually move forward on this, and this has been parked for the moment. Then there is the product liability directive, and I was recently I'm also advising the European Parliament on the product liability directive, and we had a hearing just about 3 weeks ago or 4 weeks ago. This is really proceeding as planned, and this will very likely, very likely, almost certainly be jointly enacted with the AI Act. But here, funnily enough, ironically, the interactions between the AI Act and the PLD are not explicit, which is a big mistake, I think, and this should be strengthened. That's also what I've pointed out to Parliament. Let's see what they do out of it. Now, we may come back to the question of what this really means for our lead case for the autonomous vehicle accident. And here we should note that the PLD proposal includes now liability for software, including AI, for defects. And then the question, of course, becomes, what is the defect in this case? We could have a whole lecture of 2 hours about this. So I'm going to bracket this question. If there's any questions about this, let's go to the Q&A. Just saying very briefly, because this has already been presented as well, that there is disclosure of evidence mechanism. Of course, you need a certain plausibility for that disclosure of evidence mechanism to kick in order to prevent people from basically just fishing for evidence, as we know it from the pretrial proceedings in the U.S. from pretrial discovery. And then there are just presumptions for defectiveness. For example, if the product obviously malfunctions. So funnily enough, the examples that the commission gave in the proposal I put forward on September 28, 2022, are a famous case of a glass bottle exploding. That's actually a famous case from product liability law. That's supposed to be an obvious malfunction. Also, frontal crash with a truck. That could be, if the car frontally crashes into a truck, that's what I think could be an obvious malfunction, because obviously the car should have, recognized that truck. But in many other AI cases, it's very much unclear what would be an obvious malfunction, simply because AI makes mistakes that are highly different from human mistakes. So we need a better understanding of what it means for an AI system to obviously malfunction. And therefore, this is really tricky, and it's a whole separate issue of when we can actually talk about defects and effectiveness in AI systems. I don't want to step into this debate too much. There's also another 3-factor test whereby we also have a different set of presumptions if it's excessively difficult for the claimant due to technical or scientific complexity. And this will comprise all of ML, as recital 34 mentions, which I think is technically incorrect, because there are some ML systems that are absolutely easy to understand, that are interpretable, that are easily auditable. And then there are, of course, deep neural networks and other systems, support vector machines, that are very hard to actually understand and where it may be excessively difficult. All right. So in a nutshell, how does this look like? Well, we have a breach of the AI Act, and I just want to look at the interactions here just a little bit. That will trigger a presumption of causality between fault and AI output under the AILD. And also, in my view, it should indicate a breach of the AI Act should indicate a presumption of fault and a presumption of defect under the AILD and the PLD proposals. Now, this is just looking a little bit at the general regime of AI liability. Now, let's have a quick look at what happens with respect to liability when we come to generative AI systems, such as ChatGPT, GPT-4, and others. And here, it's important to note at the outset that generative AI output, is not a product. There's clear CJU jurisprudence on this point, not, of course, on AI output. In this case, it was a newspaper article, but any kind of information that you put forward does not qualify, and rightly does not qualify, as a product under EU product liability law. So this will not be a case of the PLD. PLD does not cover generative AI output. This rather will be a question of speech regulation, I believe, because it's much more similar to speech that is made by humans. And this, in turn, is at the moment in the competence of the member states. So you have specific laws in the member states about libel, about threats, about illegal content. Famously, Germany is very strict on this based on our history, and rightly so, I believe. Holocaust denial is even a crime in Germany. Again, I think that's correct. This will also concern, of course, difficult questions, such as what happens to speech that results in bodily or mental harm. You might have heard of the case of this Belgian man who, after some weeks of interaction with a ChatGPT with a GPT-based system. It was not ChatGPT, it was a different system that did not have any guardrails and that did not have any content moderation, and that encouraged him to commit suicide, then in the end did commit suicide. So the question is, who's liable in these cases? And here we have to say that there's a potential, at least, of direct liability of developers or of the developing company for that harmful speech, because if anybody's responsible for this output, it's them. And likely you could say that there's some intervening component, some contributory negligence on the part of the person who's doing the prompts, so actually the user. And then there's the whole question of, risk assumption and so on and so forth. So it's really a tricky and interesting case. But I think that generally we might see a move toward liability of the developers for AI output, which of course would be quite a thing. This is also something that was hinted at in a famous case in the US that concerns Section 230. One of the Supreme Court justices made comments in this direction. And what's important to note is that usually intermediaries such as Meta, Facebook, Instagram, Twitter, they're not responsible for the content of users, right? Because they're hosting services. And under EU law and under US law, Section 230 in the US, it's Article 6 of the DSA now in the EU, they are exempted from liability as long as they don't basically make these statements their own, and as long as they fulfill certain due diligence requirements once they're put on notice. It's this kind of notice and action mechanism. Now, the important point to note is that generative AI systems are not hosting services. And this is something we spell out in our article, Regulating ChatGPT, precisely because hosting services are services that host other people's opinions. Whilst generative AI systems, they do not host, posts by the user. They create the output themselves. And therefore, it's very clear with L'Oreal case and other cases at CJU, to me, it's very clear that they will not qualify as hosting services, and hence they're not covered by the liability shield that shields intermediaries. And that's why this direct liability comes in. And that's a big, big question that has not been explored to this day with sufficient depth. There is also a second layer of questions, namely, what about the deployers? So deployers are people in the AI value chain. You have OpenAI, then you have some users, some professional user, let's say a newspaper agency that uses ChatGPT. But then there will often be deployers such as small boutique AI agencies, AI companies that fine-tune the model, the GPT-3, GPT-4, for example, fine-tune it for use in the newspaper by the newspaper agency. So these who are doing the fine-tuning in the AI value chain, we call them deployers, and then you have the users at the end. So are they then responsible, perhaps, for the output? Because they create it by fine-tuning the model and then also by putting in the prompts. Now, that is also a tricky question. Under current law, I would say they're only responsible if they make this their own. So if basically if they use the output and then put this forward in their own speech, integrate into their own speech, article or whatever, and do not distance themselves from that speech, but rather make it seem as if this was their own speech, or if they endorse the content, let's say. So in these cases, yes. In other cases, I'd be more hesitant. I think that it would rather be the developers who would have to be responsible. But overall, of course, we need to have some kind of regime whereby I would suppose that developers have to abide by certain due diligence rules, content moderation systems, for example, and we make a concrete proposal for content moderation also in our paper, basically extending the DSA rules to generative AI. If they abide by this, then there might be some liability shield similar to Article 6 of the DSA, because otherwise it would be very hard for developers to even, create any kind of general purpose model, because you never know what's going to come out of it, and there might be, huge amounts of harm being done by harmful speech in this model, even though you've done everything you could under a content moderation perspective. So this is really very intriguing stuff going forward, I think. We also have, of course, open questions with respect to the GDPR Article 26, which, of course, looks at basically value chains in data processing, joint controllership. Who are the controllers here who would then be liable under the GDPR, under the Article 82 private litigation rules. Much to be said about that as well, but we don't really have the time, because I want to just very briefly look at the European AI Act proposal, which was voted upon yesterday in the European Parliament, and have a look at how this affects liability. Because, again, if you breach any of these rules, then, in my understanding, you will also be liable under the product liability regime, unless, of course, it is direct speech. But even there, in direct speech, you could say that if these rules of the AI Act are breached, then at least there's a presumption for a breach of or for tort liability under member state law, which might have to be provided for specifically under member state law. So what are the steps in the right direction? Nicely enough, they took up a number of ideas from our paper, and one of them is to say that we need 3 levels of obligations for foundation models. So foundation models is the new term that the European Parliament introduced, which they take from a paper by Rishi Bhamasani. Rishi is actually a great scholar at Stanford, and he's actually coming to a conference that I'm organizing in July 4 and in Geneva. And so Rishi put forward with a team, it's the team of Percy Liang, one of the best persons on generative AI research in the world. They put forward this paper on the risks and opportunities of foundation models, came out in 2021. And now this term has been adopted, and the European Parliament says, and rightly so, I think, that we need on the first level some minimum requirements for all foundation models. And this would include, content moderation. Importantly, it includes all kinds of different rules, and you can see all this in the paper, in the regulating ChatGPT paper. But I just want to make the point that I think it's absolutely necessary that already at this level we have some content moderation tools at hand, such as notice and action mechanisms, such as trusted flaggers. Some of these Article 16, Article 22 of the DSA, some of these core rules that were really kind of innovative in the DSA, at least the trusted flaggers. Notice and action mechanisms have been around for ages, of course. Why do we need this? Because we need to tackle the problem at the source. And if we don't, because once the speech is out in the world, it's very difficult to, put it back into Pandora's box, as we all know. But that's why we want to prevent the model from, giving you details on how to do construct a biological bomb, on how to, on writing a dialogue between Hitler and Goebbels. All of this is certainly content we do not want to see out in the free world. Unless we are, of course, Elon Musk and think that Truth GPT, which he is supposedly trying to develop, is the way forward. Any systems without any guardrails at all, and these systems will be hopefully plainly illegal in the EU. And if he introduces them here, he will face major lawsuits. Second level is specific high-risk rules for high-risk applications. Why? What is the difference here? Well, they only apply if you now take GPT-4 and use it in a high-risk use case, such as for medicine, for employment, for any of these high-risk use cases of Annex 3, for example, of the AI Act, then some specific rules would kick in, such as specific rules on transparency, so Article 13, Article 15 on performance, and so on and so forth. And then, because these applications will not be done by OpenAI or by any of the other developers of foundation model, but rather by the deployers and users, we need rules for collaboration between these entities along the AI value chain. And here again, the EU Parliament has taken up our proposals pretty much by the letter. And so that's the new, that's Article 28B, I think this is 28B2A, the paragraph where we now have these rules for collaboration where it's 28B2A, I can't quite remember, where we have these rules whereby basically those parties who are liable or who are the object of, the subject rather, of the AI obligations, they have to get access, they can get access from other parties in the AI value chain if they need that information to make the system compliant. So as an example, if you have a hospital that is actually deploying GPT-4 on specific cases, to write patient letters or something like this, which I hope is going to happen very soon, to free up time of doctors for actual treatment. The hospital itself does not have any information on how the model was trained by OpenAI, so they have to have a right to gain access to this. But on the other hand, of course, OpenAI doesn't want to disclose IP rights and trade secrets, and so there are mechanisms that we need to put in place there, protective orders by the courts, special masters that can be appointed to mitigate these tensions and to resolve these conflicts of interest in the AI value chain. Okay, more of this in the paper. But what I want to stress here is that there's one component that's still an absolute killer, and that's the fact that according to Article 28B1A of the new version of the AI Act that was voted upon yesterday by the European Parliament, there's a risk management provision. So in particular, here, all of the models, every foundation model needs to develop a risk management system, needs to assess all the risks, mitigate all the risks, and manage all the risks with respect to health, safety, fundamental rights, what else? Environment, rule of law, and democracy. Well, if you are a company and you have a GPT-4-like model that can be deployed in 1 million use cases, out of which, seriously, there are 10,000 applications in high-risk cases, now good luck trying to map out, mitigate, and manage all of these risks, hypothetically, because none of these cases have been realized yet. This is absolutely insane and impossible. And I've been telling them all the time, but this is always a political compromise, and this was still in there. I hope this is going to be kicked out in the trilogue process, because if this becomes reality, this is truly a killer for AI in Europe. Why so? Because if this becomes reality, then companies will have to take like $10 million, give $5 million to the lawyers, $5 million to the techies, and they will have to, build these huge compliance teams for just this provision. This is something that Google can do. This is something that Microsoft can do. But this is not something any SME can do. If you've just raised 20 million, a couple of friends of mine, they're doing this right outside here where I'm standing, right outside in Berlin. I'm talking to a lot of startups. They've raised 20, perhaps 30 million. But if you've done that, you cannot dedicate 10 million to your compliance team. Absolutely impossible. And these people will just leave. They will leave. And they're really good. They're, Harvard grads, it's really super smart people. But if this becomes reality, goodbye to the AI ecosystem in Europe. So this is really, really bad news. Okay, so let's see how this pans out in the trilogue. I'm almost at the end here. I just want to say that in the end, with respect to liability, coming back to that, I think we need kind of a full alignment with the AI Act, whereby the idea would be if you comply with the AI Act, you're good on AI liability. If you don't comply with the AI Act, you're liable under AI liability, because otherwise developers, they would have to look at 2 different sets of rules, and this will make it crazy for them. And also for all other stakeholders. And finally, we need to develop some kind of safe harbors for developers and users so that they know if we fulfill these and these technical requirements. We look at certain performance thresholds, bias thresholds. We have fairness metrics. I also do quite a bit of work in algorithmic fairness. We've just released a paper with the Zalando Fair Machine Learning research team. If we have some safe harbors there, then there will be investment, because people will be able to say, well, if I get this right, if I get these metrics right, then at least I'm safe, and so I'm going to dedicate some money to this, and then in the end I can put a check on this. And that's what I think we need on the way forward to enable innovation still to strive to come forward in the EU. So that's it. We have a blueprint for this, the Lamfalussy procedure and capital markets law, that some of you might know, but I'm already a little bit over time. So my conclusion is, well, let's have a look at what the product liability framework will bring. Now it will apply to software and have, of course, these evidence rules and presumptions. The devil is, however, in the detail, particularly with respect to generative AI. Liability will not come through the PLD, but through speech regulation. There are also serious GDPR concerns. More on this again in the paper, and that's about it. And I hope that going forward, the EU Parliament and the trilogue will find a good solution for what we have seen in terms of rules for generative AI. Many thanks for listening, and I'm looking forward to the Q&A.
Thank you very much, Professor Hacker. Thank you very much. So now we move on to our final speaker. And I hope I pronounced this almost correctly, Professor Mezhezinska, who is a lawyer and also assistant professor at the Kosminski School of Law in Poland. And she will talk about the new rules on liability for artificial intelligence in the EU legislative proposal of 2022. So, Professor, thank you very much for joining us. Please, you have the floor, so please do start when you're ready.
Thank you very much. Good morning, good afternoon to everyone. And thank you very much to organizer, first of all, for having me here and for the opportunity to share some thoughts as to the last year EU legislative developments in the area which directly impact the issue of liability for AI. I'm in very particular position since I'm closing the panel where the topic was repeated from the first presentation. So let me be brief and just supplement and maybe approach to this issue from a little bit more practical, so the technical position. Actually, yes, there are the two main questions, indeed, whether and how we need to approach the legislative interventions to liability for AI. The ubiquity of AI suggests basically an obvious response to the first question, so the whether question says yes. The liability should be regulated, since we identify it as a technological phenomenon that may give rise to legal risk and its use is massive, etc. Doubts raised rather when we approach the method of this legislative interference. Actually, we may, of course, ask whether we are able and to what extent this interference apply. Jeffrey Hinton, the godfather of AI industry, responding the question whether we can control AI systems, with disarming honestly stated that we do not know whether we can control them, but actually we can try. So since we can only try, the more important becomes to define the legal framework for AI and liability for it. The EU, in EU, the AI liability legal framework was repeatedly avoided and postponed by the legislator. What actually constantly arose the new massive political, economic, legal questions and challenges. And finally, responding to these challenges, the Commission elaborated the regulatory package of actually 3 complementary work streams, and I will focus on one of them. I hope, yes, the slides will change, will work properly. So I will focus on proposals which were presented in 2022. So all package contains of 3 actually directions: a legislative proposal laying down horizontal rules on artificial intelligence system, which flagship piece of legislation is the mentioned Artificial Intelligence Act regulation proposal. The second, a revision of sectoral and horizontal product safety rules, which includes proposal for a deeply renewed directive on liability for defective products, which will be the subject, the main subject of my considerations, and the brand new legislative development, the directive on adapting non-contractual civil liability rules to artificial intelligence, which are also mentioned. However, an optimal legal approach to AI liability issues is still disputable. It is rather common view that contractual liability standards based on fault do not fit to handling AI-enabled products and services due to the complexity, opacity, and unpredictability of AI models. The package of directives proposed in 2022 direct us to non-contractual liability regimes. Both proposals, these 2022 proposals, aim to constitute the civil liability framework, supplementing the administrative rules provided under AI Act proposal. While the Act aims to ensure the high-risk AI systems comply with safety and fundamental rights requirements, the PLD ensures that when AI systems are defective and cause physical harm, property damage, or data loss, it will be possible to seek compensation from the AI system provider or from any manufacturer that on the production level that integrates an AI system into another product. Let's take a closer look at PLD. So the old directive, which was EU legislative response at that time, to a growing level of technological advancement of industrially originated products, introduced historically the groundbreaking, as for the moment of its entry into force, concept of liability regime for product based on risk and independent from the manufacturer's fault. The 2022 PLD proposal aims to deeply revise this existing piece of legislation into the direction of adjusting it deeply to digitalized products, including AI. The outdated scope of PLD stays beyond question, including an obsolescence of its definitions and concepts, challenges relating to the burden of proof, limitations in applicability, below the match of some value, particularly €500. So it's absolutely proper direction mentioned for many years in the literature and in the practice. The objective of the new PLD, as you may see, are to provide liability rules that reflects the nature and risk of products in the digital age and circular economy. Also, legally secure the presence of EU-based business, manufacturer, agent, importer, etc., holding liability for defective product, even those bought directly for manufacturers outside the EU, and ease the burden of proof in complex cases, as well provide restrictions on making claims. So let's look closely how the directive is going to change to cover the AI liability issues. So first, the definition of product. The product notion with the PLD has been enlarged and explicitly includes software. In general, the adopted concept of product covers physical products with digital elements, products which require software as functional component, so smart devices, Internet of Things devices, autonomous, etc. The directive applies in case of harm caused by a defective product, despite whether tangible or digital. In respect of AI, in particular, the proposal confirms that AI systems and AI-enabled goods are products, and that this is very, very clearly stated, and therefore fall within the PLD scope. So software is a product irrespective of the mode of its supply or usage, irrespective of the mode of its storage, so on a device or access through, for example, cloud technologies. However, the software is a product. However, the source code will not be treated as a product, as it is the pure information which needs to be subsequently translated into the form of any machine code. PLD will cover AI systems, whether designed to operate with varying levels of autonomy, used on a standalone basis or as a component of a product, or even as service combined under manufacturer's control with the physical product, irrespective of whether primarily physically integrated into the product or not. It covers also the directive, the proposal covers also the digital manufacturing files of any times impacted or not impacted by AI in the process of optimization of tangible items production. So they also will be treated as a product. But since the PLD applies only to commercial providers, it will not apply to freely accessible and open source software developed or supplied or modified outside the course of commercial activity. Unless it is distributed in exchange for price or personal data and not served to security reason. The next and separate question in the context of PLD is its applicability to services. The new PLD still follows the duality of product services regimes which was adopted. It's characteristic for the old PLD. And the new one doesn't apply to services in general. But since digital services, including those driven by AI, may determine the safety of the product, such related services should be considered as components of the product. And when they are under manufacturer's control, they will be covered by the directive. What means manufacturer's control is, of course, defined under the directive. It means that the manufacturer of the products integrate the component with the product, or control the modification of the product, etc. So related services which are integrated excuse me, in the product are included into the directive. Such services will be treated as components. So, for example, the smart GPS or Internet of Things, the driven navigation, or AI-driven endurance training tools, or other AI-driven personal assistance services combined with tools, sophisticated AI diagnostic services, AI-driven services supporting human decisions, etc., will be covered by directive. The next point is the entity which will be liable. So the PLD proposal adopted similarly broad as the previous one, but maybe more functional approach than previously, and assumes liability of economic operators. Economic operator is a manufacturer, can be a manufacturer of the product, or manufacturer of the component of the product or this related service, the provider of related services, the authorized representative, the importer, the fulfillment service provider, or the distributor. So the definition will cover software providers, the developer or producer of software, including, of course, AI system providers who respectively place the product of the market. This is also important. Or make this product with combined with service available on the market. Economic operator can be any kind of business that makes substantial modifications, interventions into the product or into its components. So manufacturers can be held liable for changes they make to products already placed on the market, including whether these changes are triggered by software updates or machine learning methods directed by AI. However, the liability of internet service provider, so platforms provider, this is another aspect, is governed by recently adopted DSA, which provide liability exemptions. And in this point, when we look at internet service providers and their possible intervention, we could start doubting whether the PLD will be applicable. So, but online platforms can be also held liable on the same terms as economic operators if they will play a role of related service providers, so the factual interventional rule. What kind of damage covers the new PLD? So the object of protection is any natural person who suffers damage caused by defective product and the injured person. The claim shall satisfy compensation for material losses due to the loss, destruction, or corruption of data, so including. PLD will cover manufacturing or design defects, as well as damage which results from unpredictable algorithmic behavior and decisions, such as probability-based decisions on self-learning AI. The next point which I would like to put intention on is the burden of proof and disclosure of evidence. So the construct of burden of proof adopted under the 1985 PLD created difficulties. It was many times confirmed by the European courts on the European courts level and national levels. And difficulties related to the person injured by the defective products, and actually the onerousness of these difficulties has grown in technically complex products. So in this respect, the directive also reacts and provides two innovations, really important innovations, which are the disclosure of evidence and the presumption of effectiveness, the rebuttable presumption of effectiveness. Considering these issues, the EU declined actually the more intensive, more far-reaching concept of reversal of the burden of proof, explaining this and that such idea would expose manufacturers to significantly higher liability risk. And yes, this could hamper innovations. So the proposal alleviates the burden of proof in complex cases involving AI systems, particularly when the product failed to comply with safety statements, damage results, obvious malfunctions, etc. A new PLD however, the new PLD put on an injured person burden of proving the defectiveness of the product, the damage suffered, and the causal link between the defectiveness and the damage, followed simultaneously by the rebuttable presumption, the mentioned rebuttable presumption of effectiveness, whose burden of overthrowing weighs down the defendant. And now take a look at the both acts, both proposals together. So when we look at these two proposals in common, we see that they should be perceived rather as two bricks of the same package. Therefore, any comparison of them doesn't make particular sense. They should work on a little bit other areas of regulation. PLD serves to explicitly supplement the EU consumer legislation. PLD have to be perceived as supplementary to the consumer legislation package. Therefore, it will not have such subjectively universal applicability like AILD. PLD applies to injured entity, the physical person, while AILD uses, when referring to protected entity, uses the term user and directs us to its understanding in the light of AI Act. And AI Act defines user under Article 3, Section 4 as any natural person, any legal person, public authority, agency, or other body using AI system under its authority, except where AI system is used in the course of personal and professional activity. The idea behind the old PLD was, as I mentioned, to supplement EU consumer law in the area of product safety, and basically similar perspective accompanies the new PLD too. It is applicable not only to AI-driven products. Its applicability is general in this context. Of course, keeping in mind that the AI context, the PLD proposal seems to be a timid evolution, just adaptation of an outdated act, which couldn't serve to solve problems of digitalized market. Introduced, and the new PLD actually seems to be introduced as before the old PLD, with the great caution and respect to the interest of businesses. But on the other side, it also reflects, it is a step forward. It also reflects issues identified in the EU case law, technological updates, and of course corrects the position of consumer on digital market. Also, the PLD preventive approach needs to be mentioned. PLD aims to minimize risk of digital products. Its aim is not to avoid risk, but to minimize them. it shall encourage businesses this way, businesses including non-EU manufacturers, of course, to create and place on the European market only safe products in order to avoid incurring liability. And this reflects an additional preventive approach of the PLD, which also should be kept in mind. The AILD, so in AILD, and the EU legislator addresses similarly as in PLD, the proof-related issues within the fault liability regime. So also this is the supplementary perspective, supplementing perspective of these two proposals.
Professor, I'm extremely sorry. We will need to move on to the Q&A now, I think. That's possible.
Okay. 2 sentences. So still is the open question. So the open question is whether these proposals will be sufficient. One may wonder whether ALD should adopt a more general approach and be directed explicitly not only to fault-based regimes, but apply also to non-fault-based regimes and liability grounds, or whether it should be integrated into the AI Act, which is on the regulation level. Here we have a directive proposal and ALD based on a minimum harmonization. But we need to keep in mind the turmoil that could be caused by the emergence of an additional regime proposed as a new explicitly applicable to AI a regime of responsibility for its applications. And actually, I in my opinion, these 2 proposals create a perfect starting point for future discussion and for maybe development of far-reaching pieces of legislation, which necessity or directions still seems not to be determined. So let us hope that they will be determined. Otherwise, the situation will resembles more and more the consternations of the and here I would refer to literature, the consternations of Alice in Wonderland, who, when asked the cat to direct her the proper way, received the response that actually the proper way, despite on where wants you to go. And I'm not sure whether we really really know where we want to go. Thank you very much.
Thank you so much. Thank you very, very much. So we've somewhat run over time, and I'm conscious that people will want to have a break before the next session. There were quite a few questions in the chat, but perhaps I can just summarize them into 2 and invite the panel members to quickly respond. So the first issue is surrounding this topic of EU liability has been presented predominantly as a civil law issue. And the solutions have been predominantly civil law solutions. However, we're in Hong Kong, and Hong Kong has a common law tradition. So the first point is what the panelists believe whether the points that they've made and the suggestions that they've made can actually be put forward into a common law system. And the other question is to what extent regulation of AI is practical, and whether it is the right way of actually controlling the way in which AI is developed. So on those 2 points, please, panelists, give a very quick response. Sure, Professor Hacker, sure. I think you need to unmute yourself first.
Still the old
Right.
I mean, we've been doing this for 3 years. Oh, God damn it. Anyways, very sorry about that. So each of these questions would merit, I guess, a PhD or 2 PhDs on their own. So I try to be very quick. What about common law background? Yeah, I'm not a common law person, but I've been to the US, and there's statutory law in the in common law countries as well. And I think in this case it might be actually wise to introduce rules via statutory law just to have more legal certainty, because both on the side of potential victims, injured persons, and the developers, whenever I talk to representatives there, they tell me one thing that we want is legal certainty. We want to know if we have a claim or not, and developers want to know what they have to do in order to avoid liability. So yes, I think that's a way forward, and you can see that in the UK, in the US, there are bills on the table. In the US, they will not pass, most likely, but in the UK, yes. That, I mean, there are obviously common law countries where exactly this is happening. Second point is regulating AI the correct way going forward. Well, the question is, what are the alternatives, right? I don't think it makes sense not to regulate AI at all, because there are certain risks, such as non-discrimination, data protection, opacity, content moderation, quality of training data, quality of output, that we have to address by way of regulation, because there are market failures underneath, and they won't be addressed by markets alone. How can we do it? Well, we have to do smart regulation, of course, and we have to enable companies to actually implement these regulations in an operationalizable way. As I've said, I don't think the AI Act is very good at this at the moment. I could say more about the architecture. You have this Lamfalussy procedure whereby you have general rules at the top, and then like vertical rules going down, and then very technical standards at the bottom. I think in a nutshell, that would be my idea with safe harbors. And this way we can try to get together innovation and regulation. We don't just want innovation per se, we want socially useful innovation, and that's what regulation is for. Thanks.
Thank you, Professor. I think we might just have one moment for one other panelist, if another panelist would like to jump in.
Yes, thank you. If no one else wants
Sure.
to jump in. I will be very short, as Professor Hacker, in my opinion, tackled the answers, but I just wanted to add that in addition to regulation, there are also some technical solutions that should be taken into consideration, especially, for example, for overcoming the black box issue and the question of opacity. So, for example, both explainable AI and interpretable machine learning. So explainable AI would be post hoc interpretability. So basically explaining a black box using an approximation model to characterize the accuracy, the fairness, the biases, the transparency, and the outcomes, and so on. And the interpretable one instead would be about avoiding black boxes. So intrinsic interpretability by building the model that right away obeys some specific constraints that make it more understandable by humans. And I know it was not directly linked to the questions, but I thought that in addition to regulating, integrating this into the development of AI is something that we should take into consideration. Thank you.
Okay, thank you very much. And once again, thank you to all the speakers. Thank you for your time and preparing your presentations and talking about a very interesting topic.